Boy, some mighty big news coming out of Kenosha, Wisconsin. Thomas Clair Binger's got him now. Oh my gosh, Kyle should just throw in the towel at this point. State files 2 new motions in Rittenhouse case to get donor names and use a new video. Now, in another video, I will cover the whole donor names deal. This one's going to be about that video. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
So this is an article in the Milwaukee Journal Sentinel, a real shoddy rag, but okay, let's go ahead and read this. As he watches some men exit a CVS store across the street, Kyle Rittenhouse can be heard saying that he wished he had his rifle so he could shoot them. How do you know it was Kyle? Doesn't seem to say anything about that here. At least that's what prosecutors say is going on in the short video formerly posted on YouTube. It's part of a motion they filed to use the 29-second clip as other acts evidence in Rittenhouse's trial on charges he fatally shot 2 protesters and wounded a 3rd during protests in Kenosha last August. The clip, taken 15 days earlier, appears to be taken by Rittenhouse or someone with him in a car in the evening parked across the street from a CVS store. You can see people inside and a black man as he jogs out of the store. A voice that sounds like Rittenhouse says one of the men appears to be armed. Then he says, "Bro, I wish I had my blanket AR. I'd start shooting rounds at them." In an affidavit accompanying the motion, Kenosha County Assistant District Attorney Thomas Binger, boo, says his office obtained the video last week. It does not say how or from whom. That sounds a little suspicious. We'll talk about that more here in a few minutes. The motion notes Rittenhouse had no personal interaction with anyone at the CVS store. And we'll read the motion here in a moment. Okay, so let's take a look at the video clip.
Is not seen in this video, but prosecutors say he is heard. He's heard wishing he could shoot at people he believed were shoplifting. Here is that video in its entirety.
It looks like one of them has a weapon. She hung up. Bro, I wish I had my I'd start shooting rounds at them.
2 people died when Rittenhouse opened fire on protesters in Kenosha last year. Rittenhouse's lawyers say he was acting in self-defense.
Here we have a picture of the CVS store from a distance. It looks like there's some high-rise apartments in the background. And then there's looks like an outpatient medical clinic, maybe. It could be anything. But these blue neons that run around the edges, that's kind of very similar to what typically hospitals use. Could be wrong. And here's the CVS store. Notice something. Right here are the really large white painted crosswalks you see in major intersections. And the vehicles are driving right up next to the CVS pharmacy. So this looks like an urban area. Right here is a Union Bank logo. Now, I couldn't tell it was Union Bank. It was one of my commenters on Twitter that told me that he looked at it and he deduced that it was a Union Bank symbol, but I can't be sure. So here is the motion to admit other acts filed by Thomas Clair Binger to Honorable Bruce E. Schroeder. It begins. The state of Wisconsin, by Assistant District Attorneys Thomas C. Binger and James S. Krause, and it looks like Krause has stepped in for Zaff, hereby moves the court to admit evidence that on August 10th, the defendant was recorded on video stating, "Bro, I wish I had my blanket AR. I'd start shooting rounds at them." after pulling over to the side of the road to watch several individuals who were leaving a CVS pharmacy across the street. And you may be wondering, which street? It's a good question. Which pharmacy? Who knows? The defendant apparently believed, with no actual evidence, that these individuals were shoplifting from the store. Okay, maybe they were. Who knows? It doesn't say in here how he knows that they were not shoplifting. Okay, let's move on. There is no indication that the defendant had any idea who these people were or what they were doing. That doesn't mean he didn't know. He was there. Perhaps they were shoplifting. Perhaps he knew they were shoplifting because he was right there. Who knows? The defendant had no connection whatsoever with the CVS pharmacy. How do you know that? And did not know anyone who was there. How do you know that? The defendant was watching the situation from a vehicle parked across the street, which street we have no way of knowing, and had no actual interaction with anyone involved in the incident. Quite simply, the defendant saw something, jumped to a conclusion based on exactly zero facts, and then threatened to kill someone based on his baseless assumption and wrongful interpretation. Who does that sound like? Gee, it sounds like he is describing himself. He saw something, jumped to a conclusion based on zero facts. That kind of sounds like things that Thomas Clair Binger does all the time. The defendant's understanding of the proper use of his AR, and why he puts it in quotes, I don't know. Why don't he just use rifle? And of deadly force is crucial to this case, and in that case, you're in real serious trouble, because even if you get this admitted, it only points to potentially an intent or a motive, but you still have to disprove self-defense. And therefore, your case had better not hinge on this. This video demonstrates that the defendant was eager to use deadly force in an unlawful situation. No, it does not. Come on, we all say these stupid things once in a while. Man, I really wished I had a hand grenade. I would throw it. Man, I wished I had a bulldozer. I would just run them right over. We all say stupid things like this all the time. He's only 17 years old. It doesn't mean he would actually do it. I would kick his ass. Really? I mean, we say these things all the time. It's talk, no action. There is no dispute that the defendant brought his AR, which was actually a Smith & Wesson M&P 15 semi-automatic rifle, to downtown Kenosha on August 25th. The defendant joined a group of similarly armed men at the Car Source auto dealership. Yeah, I'm not going to read all this. He's just hashing over stuff he's already claimed. The defendant's state of mind at the time that he shot and killed two unarmed individuals on August 25th and shot and severely injured a third person is a critical issue in this case, and it better not be. If your case resides on this, then you have a pretty weak case. The video from only 15 days earlier, on August 10th, he provides no indication of how he knows the date. Provides crucial insight into that issue. Oh boy. It shows that the defendant eagerly made assumptions about the intentions of others. Golly, who does that? Is it Thomas Clair Binger that does this all the time? Even though he knew absolutely nothing about what was going on. How do you know he knew absolutely nothing about what's going on? Did you talk to him? The video also demonstrates that the defendant fervently sought to insert himself as an armed vigilante into situations that had nothing to do with him. No, it just simply means that he talks a big talk. It doesn't mean that he would actually do it. Finally, and perhaps most importantly, the video proves that the defendant was ready and willing to use deadly force in a situation where it was completely unjustified. False. We all make these kind of statements. There is no lawful privilege for anyone to use deadly force to prevent property loss or stop a suspected shoplifter. Gee, Binger, you got one right. I don't have any problem with that statement. Congratulations. This evidence is being introduced for a proper purpose, namely to show the defendant's intent, motive, plan, and knowledge on August 25th, 2020. It is incredibly relevant to this case. Actually, it's either relevant or not, because it goes directly to his state of mind at the time of the shootings. No, you have to actually make a connection between his state of mind that night and his state of mind during the actual riots. Just because he had a certain state of mind on August 10th doesn't mean he had the same state of mind on August 25th. Finally, its probative value significantly outweighs any undue prejudice to the defendant. The video contains the defendant's own words. What evidence have you produced in this motion to show the judge that it's actually Kyle talking? It is close in time to the events of this case. Gee, I wonder what Thomas Clair Binger is leaving out in this statement. Oh yeah, something about place. We'll get to that here in a moment. And it pertains to the use of his gun in a situation quite similar to the one at hand. Okay, so it's actually a closer match to what happened in Kenosha that night than that stupid schoolyard fight that he got into that Binger made a big deal out of in that other motion. As a result, the state respectfully requests that the court grant this motion. Now, what did Binger leave out? Place. Okay, so let's go back to this statement that he has here. Finally, its probative value significantly outweighs any undue prejudice to the defendant. So how do we determine probative? Well, the state provides guidelines. It states here, the measure of probative value in assessing relevance is the similarity between the charged offense and the other act. Similarity is demonstrated by showing the nearness of time, place, and circumstance between the other act and the charged crime. You don't have to take my word for it. Even Thomas Binger says so in his previous motion. This is from the motion he filed to have the schoolyard fight introduced as evidence in the trial. It states here, determining relevance involves assessing the similarity between the charged conduct and the offered evidence. Similarity is demonstrated by showing the nearness of time, place, and circumstance between the other act and the alleged crime. If you read down a little bit further, he first establishes time. The other act occurred on July 1st, less than 2 months before the charged offense, blah, blah, blah. He then establishes the nearness and place. As stated above, the defendant, an Illinois resident, came to the downtown area of Kenosha, Wisconsin in both incidents. And so in this motion, he's making a big deal out of the fact that the schoolyard fight took place around in the same town as the Kenosha shootings. Now let's go back. It says here, finally, its probative value, we're talking again about the CVS pharmacy incident, its probative value significantly outweighs any undue prejudice to the defendant. The video contains the defendant's own words. It is close in time to the events of this case, and it pertains to the use of the gun in a situation that's very similar. So he establishes what? Nearness in time and nearness in circumstance. What happened to place? He explicitly mentioned in the previous motion how close in place the other act occurred to the alleged crime. And in this one here, he completely omits it. Why? Well, there's a reason. He doesn't know where the incident took place. Let's go back. This CVS pharmacy, we don't know where it is. Now you may think, well, it's in Kenosha, right? No, it's not in Kenosha. Clearly not Kenosha. There are 3 CVS pharmacies in Kenosha. I did a Google Street View of all 3. It is definitely not one of those 3. Well, what about Antioch? He's from Antioch after all. There is a CVS pharmacy in Antioch. However, this is not one of them. Clearly, this is a CVS pharmacy in a large city, or at least a fairly urban neighborhood. I checked Racine. It's not in Racine. It's not in Milwaukee. And it doesn't appear to be in downtown Chicago. So where is this pharmacy? I invite you, the viewer, to help me find out where the CVS pharmacy is located. All this raises an interesting question. Is the video authentic? Is that even Kyle? If that had been a CVS pharmacy in downtown Kenosha or Antioch, I would feel better about this actually being Kyle. At this point, this could have been filmed in Galveston, Texas, for all we know. How do we know it's Kyle? The voice sounds somewhat similar. And that's all we have. My next question, is this video a prank? Did somebody just do this and send it to Binger with an email that said, in the byline, Kyle talking about looters? Could Binger have taken that video and simply jumped on it without properly vetting it first? Notice, nowhere in this motion does he provide any clue as to how he is going to determine whether it was even Kyle. He provides no clue as to where this happened. He does provide a date, August 10th, but is that even true? Now, I don't know how the courts work in Wisconsin, but I would think that a motion has to be at least reasonably self-contained. And that is, if you're going to present a fact to the judge reading your motion, you're going to contain information in the motion that tells the judge how you're going to determine whether the fact is correct or not. For example, I would not expect Binger to identify the witness necessarily, but I would expect him to say that we have a witness willing to testify to this fact. Or if they plan on using some sort of sound recognition software, a spectral analysis, if you will, then say so. You don't have to have the results, but you could at least tell the judge that's how we're going to do it. At this point, I don't think that I would grant this motion. It's just simply too easy to make grandiose claims about a defendant, put that into the press, let the public chew on it, and then not even have the goods when the time comes. So my questions are to everyone. How do you know it's Kyle? Where is that CVS located? And finally, even if it's true, so what? So what? We all make statements like this. Wish I had a bulldozer. Wished I had a hand grenade. It doesn't mean that you would actually do it. Like my video, subscribe to my channel.